So earlier in the week, there was the headline that Judge Eileen Cannon ruled against Donald Trump in Trump's request to basically suppress evidence. Trump was requesting something that was called a Franks hearing. And as part of the showing, Donald Trump had to show that there were material false statements in the affidavit executed that was used in connection with the execution of the search warrant at Mar-a-Lago, or there were material omissions. Judge Eileen Cannon said there was no showing for there to even be what's called a Franks hearing to determine if evidence that was obtained pursuant to the affidavit should be suppressed pursuant to what's called a Franks hearing. But Judge Cannon did something in there also. Whenever she rules against Trump, she kind of also gives Donald Trump a little gift, and the media seems to neglect the little gifts that she gives him here. And this is what I want to speak to Harry Litman from the Talking Feds YouTube channel, Harry Litman from the Talking Feds podcast about. And Harry, one of the things she did say, though, is, look, we're not going to hold a Franks hearing on that issue of the affidavit having any material omissions or false statements, but she's like, I do want to have an evidentiary hearing at a later date on the issue of whether or not attorney-client privilege should have been pierced, as it was by federal judge Beryl Howell, a very well-respected federal judge in Washington, D.C., who was the presiding judge over all of the criminal grand jury proceedings there in connection with the investigation into Donald Trump's crime. So this well-respected, experienced judge, Beryl Howell, said the attorney-client privilege that normally maintains attorney-client confidences did not apply with Donald Trump and his lawyer because there was a crime that was committed and the attorney was being used in connection with those crimes, and the communications at issue were being used in furtherance of those crimes. And by the way, the grand jury ultimately indicted Donald Trump, so that would also be proof of a crime taking place for the standard for the crime fraud exception to apply. But Judge Cannon says it's my job to look at that anew, to review that decision. I may come out differently, she says. And so not only is that a kind of gift for Trump, but isn't it kind of an FU also to Judge Beryl Howell, this experienced judge who had already been presented? I think it was like an 80-page order that was issued on this. So look, you've been a leader in the DOJ. You clerked for 2 Supreme Court justices. You and I did another hot take on how Judge Cannon refused to step aside when her presiding judge told her and requested to move aside, kind of breaking all of the unwritten codes right here of kind of judges. What do you make of this?
Well, first, it's, I think, very political. Let me start again. Well, first, it's very understated of you to call this a little tip. This is frigging huge. Understand what we're talking about. It's nearly the whole case that she says she wants to re-examine. And you're right, in the same breath as saying the Fourth Amendment isn't violated and the warrant has enough particularity and no Franks hearing. But remember what this is. Donald Trump gets the search warrant after screwing around for 18 months and then getting a subpoena and then violating the subpoena. And the most sort of inculpating behavior of a whole range of and scheme of behavior. I'm really sorry. I haven't done this before, Ben, but can I just start again?
Yeah, of course.
Okay, so we'll do it right here. Okay. Well, first things first, I don't think I'd call this a little tip. This is like, this came up this week with gratuity versus tip. This is a huge gift to him, and it pales and makes the Franks decision really pale in comparison. This is nearly the whole case. Remember what's going on here. Trump screws around with the archives for 15 months. Finally, they say he's got to cough it up, and they insist, and he does, and he's totally retains all kinds of materials. Then they subpoena him. I mean, that's really the point. You're a lawyer. You counsel clients. You don't screw around at that point. But he did, and then they do the search warrant, and he goes to a lawyer and basically schemes to say, do we have to do this? Says all kinds of stuff that is a crime, but B, incredibly inculpatory. It's like the thing that is most vividly gets him with, red hands in this case. And that's the exchange between him and his lawyer that Beryl Howe holds. That's crime fraud exception, so it's not attorney privilege. Guess what, Evan Corcoran? Come on up and testify and tell us all about that. In a lot of ways, it's the most incendiary and inculpatory evidence in the whole case. And when Cannon says this, I just want to have an evidentiary hearing. Yeah, you do. I mean, as she has shown, like 10-time fooled, 11th time shy, when, she could really basically gut the case now, and in a way that it's not clear they'd be able to take up right away, but I know they're looking for ways. Now, Beryl Howe, yeah, you're totally right, completely respected, et cetera, but there is a tricky legal issue here that we're trying to figure out. I think it's fair to say people haven't nailed down, because it has to do with whether, as you say, whether Trump continued to press the point. It could be that not only is it a bit of an FU, but it's a bit of an illegal or violation of law, because the issue's already been decided, and it's what the lawyers call subject to estoppel. That's going to be a fight now, and of course she the good Judge Cannon, will decide it in the first instance. But the main thing to emphasize is, if she says Corcoran can't testify, and as you say, that was huge in the grand jury, it's just a centerpiece of the government's case. And, it's totally sort of breathtaking to see a defendant basically tell a lawyer to not comply with a search warrant from the United States. And if that's gone from the case is really terribly weakened. By my calculation, it survives, but I think that's literally the single strongest piece of evidence, Corcoran's testimony, in the whole case.
But she's doing everything she can to elongate this briefing schedule, to not make rulings, these paperless orders that drag out these disputes for months and months and months. And we saw that again recently. There was the hearing earlier in the week. Special counsel Jack Smith wanted to modify the conditions of Donald Trump's release, essentially putting on a gag order, because Trump, as a criminal defendant, does not have a First Amendment right to cry wolf and claim that the FBI and DOJ are actively trying to target and assassinate him and kill him in connection with this case, when it is blatantly false, and that is resulting in death threats and potential violent action against FBI and DOJ officers. And Special Counsel Jack Smith said, look, this is life or death. Judge Cannon, you or I don't have the luxury that Trump does, that when one of his violent thugs goes and kills someone, Trump's going to say, well, I didn't tell them to do that. They just did that on their own. So we're not going to wait until that happens. Now, Judge Cannon at the hearing seemed to reject all Special Counsel Jack Smith's team was saying she was yelling at Special Counsel Jack Smith's team throughout it. But then she realized, whether it was the clerk who briefed her or she just knew this on her own, that denying a modification request on the conditions of release is appealable. So rather than issue the order that she telegraphed she was going to make, which Jack Smith would take to the 11th Circuit, what did she do? She invited further briefing, which Jack Smith submitted. Then she issued a paperless order setting a further briefing schedule to discuss the new evidence that he submitted, dragging out this relatively straightforward dispute to, by the time she probably makes a ruling, it'll probably be closer to 45, 60 days. And then even if she makes a ruling, she'll probably deny it without prejudice, bring it up in the future to try to stop the appeal. So I want to talk about that just because that's her
MO, right? Yeah. So 3 quick points, because they're all in keeping with. The first one is Yeah, the lawyers are saying this is a matter of exigency, life and death. She blames him. She says, I don't like your attitude. We're going to keep composure in this courtroom. Somebody else can do it, if not you. She is one of the DOJ lawyers that she just loves to slap around. But legally, it's a case. It's a motion that has been decided all over the country and among other places in DC with a big DC Circuit opinion. And what Jack Smith is asking for is totally clean within those already set outlines. If it's specific, foreseeable, imminent harm to agents working on the case, that's gag order territory. And moreover, the other point you make seemed to escape her totally, but it's really important. It's not really a First Amendment case. The DC Circuit has said, be attentive to speech concerns, but this isn't about, and Trump said, it's a prior restraint of speech, the highest review in the land. No, it's a straightforward, happens every day, conditions of release for a defendant who are told, among other things, you can't commit crimes and the like. And it's really completely mischaracterizing. She takes so much more seriously than the law permits. But finally, one point. They've said, this was already after she had slapped them around for saying you didn't fully meet and confer with the defense. She's really ignored, and now ignoring again this point of exigency. And my God, what's going to happen, by the way, if a couple of FBI agents have recently been threatened? What if some lone wolf of Trump proceeds? I think there may be an opening. The article we talked about last week made it seem like the whole district and probably circuit just, she's an embarrassment. They want to dump her if they can. If she takes too long, there's a chance to me that Smith might take his shot at a mandamus saying, what? Not she got it wrong, but she won't rule, and it is exigent. And I'm not sure then that the 11th Circuit doesn't take that up, or else maybe she tries to rule the next day. But this is actually a setting, both because conditions of release are appealable, as you say, and because the DOJ is making such a record that it's exigent, and she's making such a record that she's indifferent to the exigency, where DOJ could come in and actually appeal for her not acting, as opposed to the wrong ruling that they've been waiting for, and that she cleverly, avoids issuing at every turn.
She's not hiding her corruption well. And I think that's also what's pissing off the 11th Circuit and the other judges who, in addition to not wanting, I think, there to be a judge who's ruling like that, there's no, maybe this sounds coarse or not, like there's no elegance to the way that Cannon's doing it. It'd be like an umpire who there's strike after strike, and rather than kind of creating just a different strike zone, just as randomly just calling strikes when they're clearly balls over and over again. And you can be like, well, she's outplaying Jack Smith, but that's like saying, is the umpire outplaying?
Yeah, she's the judge. Yeah. She is. She's an embarrassment. You could read between the lines of that Times article. It's gone everywhere. It's tongue wagging in Florida and above. I think there are very many judges there who would love to be done with this ongoing black eye that she presents to them.
Absolutely. Well, make sure you all subscribe to Harry Litman's YouTube channel, Talking Feds. They're on their way to 250,000 subscribers. It's free to subscribe. Go there, subscribe to his podcast as well, and hit subscribe here as well to the MeidasTouch YouTube channel. Thanks for watching, and have a wonderful day.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.